You've been very vocal for the need of judges to not think or get swayed by post-retirement opportunities while making decisions.
It is all about the propriety and perception. Somebody can draw an inference and somebody can attach motives to a particular judgment of the judge. And therefore, I think Justice Lodha had said that, or somebody else said that there should be a cooling off period.
While the present judges and the former judges have also said that the present collegium system is the best option that we have, we also see that there are certain setbacks.
See, one cannot say that Collegium is the perfect model, but Collegium is the best available model of which we can think of. We have to think of a better model.
So presently what we see is that when the artists or the journalists in this country they have to think twice before expressing themselves, because presently they are under the threat that if any kind of allegations are alleged against them, then they're left helpless.
This is happening mainly because we as citizens, we don't respect the fundamental right under Article 19(1)A conferred on the other citizens. That's where society is going wrong.
The ED has been used to kind of go after people. The Supreme Court has also on several occasions observed that the conviction rate in these ED matters is very minuscule.
So, lot of course correction is required on the part of investigating agencies. Because if they don't act properly, they act arbitrarily. They are themselves reducing the importance of important legislations like PMLA.
What is that driving factor for you that has kept this fearlessness alive for so many years?
My only endeavor was that I should decide each and every case in accordance with law and in accordance with the law laid down after interpreting the Constitution.
Of all the trees in the dense forest weathering the storms is the one whose spine never broke, the upright oak. These words were written by poet and advocate Raju Murray, honoring the legacy of the Supreme Court Judge, Justice Abhay Oak. This wasn't just a poetic tribute, but a reflection of the majority sentiment of the bar towards the revered, fearless Justice Oak. Dear viewers, I'm Anmol Bawa, and today we are in conversation with former Supreme Court Judge, Justice A.S. Oak. As a judge, Sir has left his mark as someone who's a stickler for judicial discipline and taught many lessons in humility. The bar remembers him as a judge who would treat a junior and a senior advocate alike, one who keeps the duty for dispensing justice paramount, even to the extent that he would utilize his travel time to read briefs and prepare for hearings for the next day. His dedication towards dispensing justice is also evident from the fact that he would barely take any leaves during his entire tenure. And even on the last day of his tenure, he delivered 11 judgments consecutively, despite the fact that his mother had passed away just a day before his day of retirement. Sir, we are deeply honored to welcome you at LiveLaw in this conversation. Sir, I would begin by taking you to your flashback, your farewell speech, where you said that once you're a judge, your judgeship is life and life is judgeship. In your 22 years career as a judge, how was that life different from the life of advocacy?
One major difference was that you lead very secluded life, because from a lawyer you become a judge, then you have to cut off contact with your lawyer friends, you have to cut off contact with various other people, and you have to lead reclusive life. But you don't feel effect of that. The reason is that there's so much of work to be done. I mean, for a judge or a judge of a constitutional court, for that matter, judge of any court, work never ends. There is always some pending work. So initially you feel that this transition is difficult, but once you start functioning as a judge, you start enjoying it because there is only work and nothing else but work.
So in the same speech, you mentioned that the Supreme Court has become a CJI-centric court, and you had rooted for automatic listing of cases, as is done in several other high courts. How do you think this automatic listing would make a difference?
It is not all about automatic listing. The difference between the High Court and Supreme Court I will highlight. In High Court, there is a fixed roster. I'll give an example. Chief Justice notifies the roster, say for a period of 2 months or 10 weeks. One particular bench will take up first appeals, one bench will take up latest patent appeals, one bench will take up bail applications. Sometimes it is bifurcated like this, that one bench takes up bail applications up to a particular year and current bail applications are taken by other bench. So in short, when a litigant files a case, he knows before which bench the case will come up. In Supreme Court, no such system is there. In Supreme Court, you have case-wise, subject-wise allocation. So 3 benches may have same subject. So ultimately when new matters come up, the fresh matters as we call it come up, lot of discretion is given to registry because there is no fixed roster. In fact, in high courts, the practice is when Chief Justice signs the roster, he also signs one more order that is regarding default benches or drop benches. So if bench number 2 recuses, the Chief Justice lays down, it will automatically go for bench number 4 or 5, whatever it is. So that even if there is recusal by a roster judge, registry does not have any discretion. It automatically goes to that. And once you have this practice in place, then there can be some kind of automatic listing that if case is ready today, it should be listed on 7th day after it gets ready. So that was the whole purport of what I said. See, ultimate object is, no doubt Chief Justice is master of roster. He can decide which judge can hear which cases. But if it is laid down properly, then the manual intervention by the registry reduces. And we must rule out manual intervention in such matters.
So, you've also in the past been vocal of the need, in one of your decisions perhaps, you said that the religion, the caste of the parties should not be mentioned in the cause title in the judgments that are given by trial courts and high courts. Even after so many years of independence, do you think that somewhere, consciously or unconsciously, the judiciary's functioning does these things, caste and religion, they are mattering, they are hindering?
Now, about mentioning the caste and religion on the record, in the sense that in the judgments, I think it was being done mechanically. I don't think it was done deliberately. But we should keep on introspecting. And after 75 years of constitution, we should be giving correct signals. Therefore, I said that don't mention caste and religion of a litigant in the cause title of the judgment. But I don't think that is done deliberately.
And so on the aspect of judicial decision making, you've been very vocal for the need of judges to not think or get swayed by post-retirement opportunities while making decisions. Would you like to elaborate more on this?
See, it is like this. I don't think anybody can say that the decisions of the judges get influenced because they want some post-retirement post. It is the other way around. If immediately after retirement, judge gets a post, somebody can draw an inference and somebody can attach motives to a particular judgment of the judge. And therefore, there was, I think Justice Lodha had said that, or somebody else said that there should be a cooling off period. So that today you retire, you don't accept any post, say, for a couple of years, and then you get the post. So it is all about the propriety and perception.
So you mentioned cooling off period. So there's been discussion and there's been like different views on what should be the specific cooling off period. Some people say it's 6 months, some say you just mentioned years. So what according to you could be a common ground in deciding a cooling off period?
See, it will all depend on the nature of the post which is being offered to the judge, the tenure of that post. It all depends on that. So it can't be that for every post there is a fixed cooling period, but there has to be a cooling period. So that this sort of allegation is not faced by the judiciary that you are interested in a particular post and therefore a particular judgment was decided in a particular manner.
So you mentioned about allegations on judiciary. In the recent times, we've seen that the common man's faith is eroding in the judiciary. You've also said it in the past. What do you think is the root cause for this?
No, I have said that, no difficulty on that. I have said that we must introspect. Judiciary must introspect. See, main reason is that delay. Delay is the main reason. And the reasons are well known. We are not maintaining ideal judge to population ratio of minimum 50 per 10 lakh. And therefore, if you have judge to population ratio of only 20 or 21, naturally there are bound to be delays. So delay is the main area of concern, and therefore common man feels that he is not getting justice. Delay is, of course, delay is not the only ground on which one can say that faith of common man in judiciary eroded. There may be other grounds also, and there are other grounds.
So when we talk about judiciary, we also talk about the trial courts, the courts at the grassroots level. Article 235 refers to the courts as subordinate courts, which are below the High Court of the Supreme Court. Do you think it's the right terminology we should be using? What is your take on this?
I don't think it is right, because I can tell you, I'm not saying it orally. After I assumed the office of Chief Justice of Karnataka High Court, I passed an office order on the administrative side that hereafter no court should be referred as subordinate court or lower court. Because there were lower court branches, and then our district judges used to refer in their judgments that lower court said this, lower court said that. So I passed an administrative order that no court shall be called hereafter as lower court or subordinate court. All courts can be called as either trial court or district court.
So what do you think is the reason for this neglectful mentality towards our trial courts? What is contributing towards this mentality where we are unconsciously also we keep referring to them as lower courts?
Now, for example, in Supreme Court, the registry used to put a remark, lower court record not received. So there also I corrected, I said, why are you saying lower courts? You say trial court record not received. Instead of LCR, you say TCR, trial court record. I think it's all about the approach. Maybe perhaps during last 75 years, when we discuss judiciary, we discuss only High Court and Supreme Court. Because the trial courts and district courts, sessions courts, these are all courts at grassroots level which deal with litigation of common man. And someday we must make a study that after district court decides a case, how many litigants can afford to approach the High Court. So these courts are the most important courts. And I have said so in my judgments also that perhaps during last several years we neglected those courts. More importance should be given to those courts. In fact, whenever I go to law schools, I always tell the young law students, don't consider practice before trial and district courts as inferior practice. It is as important as practice before the High Court or Supreme Court. So we need to have a change of approach.
So one of the most debated issues presently is also with respect to the Collegium. We definitely need a requirement, there's a requirement for a foolproof system for the appointment of judges. Now presently in the Collegium system that we have today, this executive seems to have a primacy over appointments. While the present judges and the former judges have also said that the present Collegium system is the best option that we have, we also see that there are certain setbacks. So what according to you would be a perfect model?
See, look into the functioning of the courts. If we study the functioning of the courts and especially appointments to the High Court during the last 75 years. See, one cannot say that Collegium is the perfect model, but Collegium is the best available model of which we can think of. We have to think of a better model, and perhaps only option is to improve the existing Collegium system. And I don't think there is a scope for the executive to interfere, because the law is very clear in the two judgments of the Supreme Court that after the Supreme Court approves a recommendation, at highest the government can return for reconsideration, and once it is reconsidered and reapproved, government has to sign on dotted line. There is no scope for interference in the sense that now the entire Collegium procedure is on the website of the Supreme Court. When Chief Justice Sanjeev Khanna was the Chief Justice, he has done that. So when Chief Justice of High Court along with two senior judges recommend a name, the Chief Minister and Governor have some say in the sense that they can put their remarks while sending the file to the central government. And when file is received from the central government, there is a very detailed IB report and the views of the central government which are placed before the Supreme Court Collegium. And then Collegium decides. So I can say that the executive has its own say, but ultimately the final decision rests in the Supreme Court Collegium.
So when we're talking about this particular recommendation system, by the time the names get recommended, in this whole system, somewhere in the public eye, the system gets a little shrouded. There is also concerns regarding the confidentiality of these discussions that happen within the Collegium. But then the flip side of the coin is that democracy demands transparency. So how do we deal with this contradiction?
Firstly, I must tell you that the transparency has to be balanced with issue of privacy. I'll indicate what I mean. Today, perhaps you must have heard about it, the Chief Justice of the High Court, they have a job in hand to persuade competent lawyers to accept judgeship. Now, if some competent lawyer says yes, and then naturally there will be deliberations in the Collegium meeting. Some judge will feel, member of the Collegium, no, he is not a good lawyer. Somebody will say he is a good lawyer. Now, if this is reported and this is put on the website, and ultimately that person is not appointed a judge, it will affect his professional career. So both the things have to be balanced. And today when we have a system where the state government and central government has a say, surely we must trust the Collegium. Of course, many have criticized the Collegium. There may be substance in that criticism. But today we are discussing only the system as a whole. Only because the system does not work properly, per se system doesn't become bad. Maybe those who man the system will have to make course correction.
So you've also one such judge who is known to never differentiate between a senior lawyer and a junior lawyer before you. You've always treated them equally. When we're talking about the present designation system, the senior designation system, we are presently observing that a lot of people want to be designated as senior advocates just so that they can use the title to earn more and more money and really not give back much to the society. Somewhere, what I have also observed is that the humane aspect of the lawyer and the essence of being a senior advocate is dwindling. What is your take on this?
The first part of making differentiation between a designated senior lawyer and one who is not a designated senior lawyer. See, as judges, we look at the litigants and the cause. The lawyers are only the medium. They only stand up and tell us what is the case about and what is the law involved. But ultimately, as judges, we should be trained to look at the litigant and not at the lawyer. Now, senior designation system, why some lawyers aspire to get designation and what is the effect of designation? This is something which I won't be able to offer comment. You better ask this question to some lawyers. But per se, I feel that only because you are senior, designated senior, I don't think that your presence should count in the court when it comes to decision making.
So, you've also given decisions with respect to right to freedom of expression and speech. And one of such landmark decisions was the Imran Pratap Garhi case, where the issue of artistic freedom also rose. So presently what we see is that when the artists or the journalists in this country they have to think twice before expressing themselves, because presently they are under the threat that if any kind of allegations are alleged against them, then they're left helpless. They are left helpless. They have to fend for themselves. And if we see presently India's freedom of India in terms of the International Freedom of Speech Index, there's been a consistent drop. In terms of Free Press Index also, there's been a consistent drop. People are really thinking twice before expressing themselves. And in this case, we've seen that courts have not been in a very proactive, have a proactive stance when it comes to protecting their rights. So, where do you think is the issue, and how can we address it proactively?
See, the first part of it. See, if you see Article 51A, the first fundamental duty is to uphold the Constitution, to abide by the Constitution, to respect its ideals. Article 19(1)A is part of the Constitution. So, if I have freedom of speech and expression, it is the duty of the other citizens to protect that right. when I say something, they can exercise their right of freedom of speech and expression, and they can express a counter view. This is happening mainly because we as citizens, we don't respect the fundamental right under Article 19(1)(a) conferred on the other citizens. That's where society is going wrong. And that's perhaps we have said in that Imran's case that 75 years of existence of Constitution, our shoulders should become very strong and very bold. And therefore, what is necessary is that we must start respecting others' right to speak and others' right of freedom of speech and expression. You may feel that the views are wrong, then you must say so, that I don't agree with this particular views for ABC reasons. And as citizens don't respect the other's right, then there is a tendency to go to police, pressurize the police to register an offense. And then police come out with all those sections. About the second part, I am nobody to comment whether courts are not active or proactive when it comes to protecting Article 19(1)(a) freedom. But I feel that it is a duty of the courts to interfere when the freedom of speech and expression is infringed. It's the duty of the court, because if courts do not do that, who else is going to do?
So, you've also been a champion for environmental rights. And in your judgments, you've always pointed out wherever MNCs or big industrial companies have faltered. There have either not been, clearances, or there have not been timely compliances on their part. And when these compliances don't take place, it not only affects them, but it also affects the entire industry and the economy, so to speak. What message do you think, in your experience as a judge, would you like to give to those MNCs and companies who are not doing timely compliances or are flouting or are violating the environmental rules? Would it be better to, warn them with a contempt, or would they realize it eventually with years of litigation?
See, there again, the fundamental duty comes into picture. MNCs who are in India, they are all manned by Indian citizens. Mostly they are Indian citizens who are in the management, who run the company, who take decisions. When they take decisions as part of MNC or part of any company, any enterprise, we'll put it that way, they forget their fundamental duty of protecting and conserving the environment. See, ultimately, when a particular company consists of human beings, decision making by human beings. So is it not the collective responsibility of a company or any association or entity which consists of human beings to follow the basic fundamental duty of protecting and conserving the environment? So perhaps there's complete wrong approach adopted by the companies. See, there's nothing wrong if companies feel that they want to earn profit, but profit can't be at the cost of the environment.
So we've also been seeing a lot of media trial that's been happening with respect to accused who've been charged of certain offences, be it sedition and etc. They've also gone to the extent of calling them anti-national or terrorists, when in fact later on they're either acquitted or the police does not find any adequate evidence against them in investigation. But the whole procedure in itself becomes a punishment for them, that they are sent into jails and they don't get the bail. Where do you think is the solution for such media trials? Should the court take a stern view on these things?
I don't think that courts should interfere. The reason is, ultimately, if somebody in the media is expressing the views without even looking at the material collected during investigation, course correction is required by the media. Why courts should be sensitive? I personally believe that, if I am, for example, I am hearing a criminal appeal where the offense is very heinous offense, it may be against society. Maybe some media people will write an article that here is a case where the Supreme Court or High Court, as the case may be, must not only confirm the conviction but enhance the sentence. As a judge, I should not be bothered about it, because when I sit as a judge, I look at the evidence, I reappreciate the evidence, and then I will take a view whether guilt of the accused is proved beyond reasonable doubt. If I come to the conclusion on the judicial side that guilt is not proved, that's the end of the matter. I have no choice to pass order of conviction. So it is ultimately for the judges to remain independent, because you can't stop media, you can't stop expression of opinion that somebody feels that no, this man has committed an offense. That somebody should not be saying that without looking at the investigation papers. For example, if there is a charge sheet, the charge sheet is available. Somebody can go through the charge sheet and then report what is the material available. But I don't think, if I feel that if judges have that kind of discipline, they won't get affected by media trial.
So you're also one of those few judges who've passed decisions that have made the Enforcement Directorate very uncomfortable. We've seen, there's a specific impression in the society that the ED has been used to kind of go after people. And it has been abused. And when these individuals who are not lawyers, who don't know the ABCD of law, they are again left to fend for themselves. Years go by and a lot is put on stake. And then the Supreme Court has also on several occasions observed that the conviction rate in these ED matters is very minuscule. Now, these individuals cannot really prosecute the state or the ED for all these things. So, where do you think a solution would come from?
First thing, when we decide a case sitting in the court, we don't bother whether somebody will get offended. For example, if there is a case where bail is sought in a prosecution under the PMLA, where naturally ED is the agency which is prosecuting. So when we decide that case, either sitting in the High Court or in Supreme Court, we are least concerned what others will feel or what the prosecuting agents will feel about our order. Our duty is to examine whether a case is made out for grant of bail. If case is made out for grant of bail, we should not hesitate to grant bail. And when case is made out for, there are of course different facets. Say for example, NDPS Act, UAP Act and PMLA Act, there are stringent conditions or stringent restrictions on the court granting bail. But we have taken consistent view that if there is long incarceration and trial is not likely to progress, in that case, if we don't release a person on bail, that will be a violation of his rights under Article 21. So therefore, I don't think when we decide cases, we think that, we are doing something against ED or some prosecuting agency. When we decide cases, our approach should be to uphold the law as it stands. And I do believe that even after these special legislations, the basic rule laid down by Justice Krishna Iyer that bail is the rule and jail is the exception, that continues. Only thing, there is some modification made to that rule by these special enactments. So we don't think that, we are deciding something against ED. Whosoever is the prosecutor or whichever is the prosecuting agency, we only decide in accordance with law. Now, victimization is another issue. Now, victimization is something, for which we need a lot of course correction on the part of the investigating agencies. Maybe regular police, maybe NIA, maybe CBI or maybe PMLA. And I think a lot of course correction is required. Perhaps because of delays involved in the court, even if somebody is framed, it takes time for him to apply for bail and get a bail, or he has to go up to the highest court. So that is where system is going wrong, that though a person is entitled to bail, he doesn't get it at the threshold. He has to travel up to, say, High Court or to the Supreme Court. So it's a very broad issue where now time has come for the authorities to rethink about it, because see, if you look at PMLA, keep aside what happens at grassroots level or what happens in practical terms, it is an important legislation in the sense that it seeks to curb the menace of money laundering. Your money laundering can affect your economy. But if you are going to use that legislation for purposes which are not genuine, then this kind of a situation arises where people feel that somebody is being victimized by applying PMLA, because everybody knows that getting a bail under PMLA is very difficult. So a lot of course correction is required on the part of investigating agencies, because if they don't act properly, if they act arbitrarily, they are themselves reducing the importance of important legislations like PMLA.
So, a recent debate has also erupted regarding criminalization of adolescent love, where probably the girl is below 18 years and the boy is near in his 20s and they elope. But the parents of the girl, just to save the family honor, would press POXO charges against the guy. And then it is really like a sad love story that is dragged to the court. There have been several opinion articles criticizing this particular tendency of misusing the POXO provisions in such a way, but at the same time we also have to keep the actual objective and the actual aim of the law intact. So where is the middle ground for this?
If you want to find out a middle ground, only legislature's intervention is required, because there is no discretion in such matters, because that age is fixed, and if there is a relationship, POXO Act is attracted, then police have to arrest the person. So therefore this is an area where the legislature must have a rethink and legislature must intervene. And there are other cases where maybe say adolescent girls, 13 years old, 15 years old girl suffers. Unfortunately, in our society, she doesn't get support of her parents. This is another extreme case where parents simply wash off their hands. And then the position of that victim becomes very helpless. And then, of course, the one case we dealt with on judicial side, in that case, the poor girl had no option but to go and stay in the family of the accused. So this is something which happens in our society also. So one case is where parents insist that FIR should be filed. There are other cases where there is a genuine victim, where parents simply don't bother to even to support the victim. So lot of debate is required, and I personally feel that legislature must intervene. Time has come for legislature to intervene.
So when we also talk about the safety of women lawyers practicing, there's a recent Bombay High Court judgment that said that the POSH Act would not be applicable where a lady advocate files a sexual harassment complaint with the BCI, because there are no employee and employer relationship that is established here. Then so if not the POSH Act, then what is the better alternative that we have for ensuring protection of women lawyers?
No, firstly, I have not seen that judgment. I'm sorry, I have not seen that judgment. But we are saying that the judgment takes a view that if a woman lawyer is not treated properly in her senior's chamber, she can't go to bar council. Is that you are saying? That's
yes,
the view taken,
yes.
Right? Again, it's a debatable issue, but of course, one thing is very clear, that when a woman lawyer works in a chamber of a senior, such things should not be happening at all. The woman lawyer has to be treated with respect. And of course, I am just saying it offhand because I have not seen the judgment. But if a senior indulges in a behavior which offends the dignity of a woman junior, we have to examine whether it will be a professional misconduct. That aspect also needs to be examined. If POSH can't be applied, why it can't be a professional misconduct? Of course, I am not sure about it. I am saying that this thought process has to be considered. So ultimately, we say that advocates are in a noble profession. Is it not part of the noble profession that a senior treats his junior with dignity?
So you also said that you will not be taking up any assignments after your retirement, but if you do plan to take up assignments, you will be one of the most sought after arbitrators, and you would definitely be earning lakhs and lakhs. But you clearly chose to take a simple path in your life, especially in this particular time and era where people are actually going after worldly pleasures. What really made you retain to your own ground?
See, I'll tell you one thing. It is purely my personal decision, my personal view about it. I won't blame any other retired judge if he takes up arbitration. Or for example, there are some statutes which provide that a person holding a particular post has to be a former judge of the Supreme
Yes.
Court. So there is nothing wrong if somebody accepts it. Personally, what I thought was, I worked as a judge almost for 22 years, and I may have decided several cases. So after occupying the highest office of the Supreme Court judge, I should not do again adjudication work. And a lighter vein, I'll put it. That's not the thought process on the basis of which I come to this conclusion. But sometimes I felt that I have given enough hearing to the lawyers during the last 22 years. So again, to give hearing as arbitrator, I thought that better not to do it. This is of course in a lighter vein.
Sir, we started this conversation on the note of how fearless you are as a judge. What is that driving factor for you that has kept this fearlessness alive for so many years?
Frankly speaking, I never considered that I should be treated as a fearless judge. My only endeavor was that I should decide each and every case in accordance with law and in accordance with the law laid down after interpreting the Constitution. So I had to decide within four corners of Constitution and the existing law. And that is the minimum which is expected from a judge. So I tried to do that during my 22 years journey. I may have gone wrong also somewhere, but I honestly tried to do that.
Sir, now that we come to the end of this conversation, I'd like to highlight that you're one of the rarest judges who's been really sought after as a mentor, as someone who's looked up to amongst the bar members. And your retirement has been very saddening for a lot of people. How are you planning to keep in touch with the legal fraternity even after the retirement?
One, I offered my services to all law schools and law colleges, which I am doing now. After retirement, I must have delivered more than 10 lectures in different law schools and law colleges. Secondly, Maharashtra, Bar Council of Maharashtra and Goa, they are conducting this CLEP, the Continuous Legal Education Program, and BLEP, Basic Legal Education Program. I always offered my services to them. I had told them that I'll be available now more frequently. In fact, on LiveLaw, my article on Kolhapur bench was published. And I have said that I don't wish to turn the clock back. I'm only on decision-making process, and errors should not be committed again. But there I have said, if somebody calls me to train the young lawyers from these 6 districts, which are now gone to Kolhapur bench, I'll be the first person to do that. So, at any place where lawyers require my presence, not that I'm a great teacher, but I can guide them based on my long experience, that much I can say.
Thank you so much, sir, for your time. Thank you so much. Ladies and gentlemen, we now come to an end of this candid and fearless conversation. Please do like, share, and subscribe to our YouTube channel for more such videos.